Hi Con Law class, it's Professor Opterbeck, and as promised, here is the last set of review slides. As discussed, I have to kind of compress them all, and I'm going to do this in a sort of a very brief summary fashion. Essentially, I'm going to try to give you kind of an overview and the basic rules of the areas that we covered in weeks 9 through 14. I don't want to give you the sense that all you need to do is kind of dump these rules in. Remember, we do want to see issue, rule, explanation, application, and a conclusion in your answer on the exam. But I do want to give you this last review because I said I would do that. So, the previous review slides, I went through substantive due process and privacy through the abortion cases. We then looked at sodomy and same-sex marriage cases. Recall that Bowers in 1986 upheld a general anti-sodomy law. Romer v. Evans rejected a Colorado constitutional amendment, and it purported to apply rational basis scrutiny. And then Lawrence v. Texas in 2003 overruled Bowers. And then we talked about the Obergefell case, which rejected state bans on same-sex marriage and applied really both a kind of hybrid due process and equal protection rationale. We talked a little bit about that in the in-class review session. We talked then about the right to die cases. We mentioned the Cruzon case in 1990, which said that a competent person has a constitutional liberty interest in refusing unwanted medical treatment, and that this extended, according to the court, to refuse life-saving nutrition and hydration. We then looked at the Glucksberg case in 1997. The court noted in that case that there were really two features to due process analysis and to try and decide whether we're going to recognize a substantive due process claim. And the first is whether the right is fundamental, and that is whether it's deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. And then whether there's a careful description of the asserted fundamental liberty interest that the plaintiff is claiming. And the majority of the court decided in Glucksberg that there is no right to assisted suicide, no fundamental right to assisted suicide, and applied rational basis review to assisted suicide statutes. We then turned our attention to the Equal Protection Clause, and we noted the three general approaches to review under equal protection. Remember, we talked about the fact that we're talking about substantive due process. Someone is asserting a right as against the government. For equal protection, we're saying someone's asserting a right as against the government, but the government is making distinctions between different kinds of people. So in the different kinds of review, strict scrutiny, we said applies generally to race discrimination and other kinds of inherently suspect classes, and it requires a compelling government interest and the least restrictive means. And we said that there are some cases in which there seems to be a sort of relaxed strict scrutiny, and we looked at that in the context of some of the affirmative action cases. Intermediate scrutiny, we said, is generally for sex or gender discrimination, and we said that's an important government interest, and the government measure is substantially related to that interest. And then we said really for all other kinds of distinctions in the law would be rational basis scrutiny, which really is kind of our default position. So socioeconomic laws, classes that are not deemed inherently suspect, like age and race, only need to show a rational relationship to legitimate ends. But we also noted that sometimes the court will apply what seems to be a heightened form of rational basis scrutiny, particularly if the legislation seems to exhibit an animus against one particular group. And we looked at the case involving hippies to give us that. So drilling a little bit into equal protection and race, we looked at the history of this. We saw the Plessy case saying that separate but equal is okay, and we saw Brown in 1954 in the education context reject separate but equal. As we looked through the history of Brown, we looked at the different remedial cases, and so you should be familiar with some of those cases and the kind of remedies under Brown that the court upheld or didn't uphold, and in particular note the trend toward, especially as sort of time went on and time goes on, of distinguishing between de jure segregation, that is segregation that's enforced by law or historically was enforced by law, and de facto segregation, which is segregation that sort of arises not by operation of law but just sort of by other incidental facts, like, for example, where people happen to live. And we saw that where a legislative scheme or a regulatory scheme is really trying to change de facto segregation, very often the court's going to say that's not really what Brown was addressing, and might very well strike that down. We talked then about equal protection in the context of race for facially neutral laws which have a disproportionate effect. In general, we said a facially neutral law is not a violation of equal protection, but the court may infer a discriminatory intent from a discriminatory effect. We also talked about the fact that just some racial animus underlying at least some of the legislators who enacted the legislation might not be enough, but we do need to show that the racial animus is actually connected to some kind of improper effect. And we looked at some ways to look at this. The Arlington Heights case gave us some sort of good factors to consider to determine whether we're going to find a intent and effect that go together in a way that that the court might invalidate the statute. We then talked in the context of equal protection about racial preferences, and we began with contracting set-asides. And as we looked through those cases, we saw that the court is generally going to apply strict scrutiny to these, even if they're, as they usually are, designed to set aside opportunities to enter into contracts by minority contractors. The court will apply strict scrutiny. Very often the court's going to find that if there's some history of discrimination in the industry or some reason to remedy discrimination, very often the court will find there is a compelling interest in having a set-aside, and the real question is going to be, is the set-aside actually narrowly tailored? And we talked about a case that isn't really talked about in our book, but I gave you this information, the Paradise case and the factors under that case that often help the court determine whether a particular set-aside scheme is in fact narrowly tailored. We then moved into racial preferences in university admissions. And as we looked at these cases, again, we saw that these programs are generally affirmative action programs. They're designed to facilitate and encourage traditionally disadvantaged groups from being able to participate in university education, but the court is going to apply strict scrutiny to these. The court has found that racial diversity, not quotas, but racial diversity in education is a compelling interest because it benefits education and all of the students. But that race cannot be the defining feature of the application, and yet narrow tailoring, because we found the compelling interest in diversity itself, but the narrow tailoring is what the court will look at. Doesn't necessarily mean every possible race-neutral alternative has to be considered, but you have to look through those cases and see the ways in which the court has decided that a plan may or may not be properly narrowly tailored. We also looked at racial preferences in K-12 education. And there, outside of Brown, and of course Brown is addressing the circumstance when the law itself is enforcing or affecting some kind of racial segregation, and that kind of thing under Brown is going to be stricken down. But here we're talking about if a school district wants to promote diversity in K-12 education outside the context of a history of de jure segregation. In general, the court's going to look at those kinds of plans under strict scrutiny. And the court is not going to allow plans that merely strive for racial balancing. But what the court might allow is looking at things like, say, where are we going to put a new school? Or how are we going to set up certain kinds of programs and the availability of those programs to provide incentives or otherwise encourage racial diversity in K-12. Then under equal protection, we looked at the question of racial gerrymandering. And we said that strict scrutiny will apply where there is redistricting legislation that is race neutral on its face, but that, and this is the language of one of the cases we looked at, is so bizarre on its face that it's really unexplainable otherwise than on the basis of race. Now, as we talked about it and looked at some of these cases, we saw that merely the shape of the district is not going to be enough to say that it's a racial gerrymander. But the fact that the district is kind of bizarrely shaped might help supply an inference that there's a racial gerrymander. On the other hand, the court has said a showing of the bizarreness of the shape of the district is not required. It's just one thing that could support an inference of a racial gerrymander. And essentially what the plaintiff has to show is that in constructing the districts, the legislature subordinated traditional race-neutral principles for the structuring of legislative districts, which include compactness, contiguity, political subdivisions, and other things that are not racial considerations, and that those things were subordinated to racial considerations. So you have to look at that line of cases and kind of think about what sort of application you might make. We then looked at equal protection in gender discrimination, and as we've discussed, the cases suggest so far that intermediate scrutiny will be applied. As we looked at how intermediate scrutiny is applied in these cases, essentially we see kind of a theme that says gender can't be used as a proxy for other more germane bases of classification. And outdated conceptions of gender roles are not really going to be thought of generally as valid justifications for distinctions based on gender. But as we saw, there may well be cases in which distinctions based on gender pass intermediate scrutiny. It depends on the context. We looked also at equal protection in the context of alienage, and as we noted, the Equal Protection Clause applies to persons, not only to citizens, and so therefore distinctions made on alienage will be looked at under strict scrutiny. We also looked, however, at the governmental function exception, and we saw that the court will give greater deference to alienage classifications where those classifications relate to public policy functions that go to the heart of representative government. So we talked about perhaps things like qualifications for running for office or for serving as a judge or things like that that might go more to the heart of representative government. We also talked about the fact that federal restrictions on aliens can be quite a bit broader than state restrictions. State restrictions are subject to equal protection under the 14th Amendment. The federal government in the kind of structural constitution has nearly plenary authority about alienage. Although we talked earlier in the semester about separation of powers issues, because it is Congress that has the authority to establish uniform rules of naturalization. And then the question is, what is the role of the executive with respect to what Congress has done concerning what the rules of naturalization might be? We move then into a discussion of equal protection and sexual orientation a little bit. And our big question there is, what is the meaning of Obergefell? Traditionally, sexual orientation has not yet been viewed as a suspect class under equal protection, which would trigger strict scrutiny across the board for distinctions made on equal protection. What we do have is the line of cases saying that state anti-sodomy laws, which may apply to homosexual persons or heterosexual persons, that state sodomy laws violate the substantive due process right of privacy. And we've also seen in Obergefell that state laws, federal or state laws outlawing gay marriage violate a right that seems to be a combination of substantive due process and equal protection with respect to this fundamental right of marriage. We don't know yet whether the court is going to say at some point that sexual orientation is a suspect class, and so then across the board strict scrutiny applies, and that's an interesting kind of open question. We talked about equal protection and disability a little bit, and we saw that the court generally applies only rational basis to disability. And we talked a bit about why that might be the case, whether that's sort of good law, good policy or not. But one of the things we talked about is the fact that Caroline Products footnote 4 talks about discrete and insular minorities, and the category of disability may simply be too broad to suggest whether any particular kind of disability is a discrete and insular minority. We then talked about equal protection and voting. And as we looked at this, we said that there is no basic right in the Constitution to vote in state elections. And what we mean by this really is that there's no basic rule in the Constitution that says to states how they have to structure whether or not certain offices are elected offices. Now, of course, state constitutions will have requirements within their own constitutions that different representative offices are subject to elections. And there, the Supreme Court has said, once the franchise is granted, once there's an office that the state says, yes, this is something there will be a vote on, then the state cannot draw lines that are inconsistent with equal protection. So there is a fundamental interest, a fundamental right in voting. There is certainly a fundamental right in voting in federal elections, which are established according to procedures set by the federal Constitution. But once the state extends a right to vote, then it has to be consistent with equal protection, and lines that are drawn on bases of wealth or property or race are going to be disfavored. We then talked about the fact that when a statute is distributing the franchise to vote, at least heightened review is going to apply, although we said that the court has said that felons can be disenfranchised, that sort of setting up a class of felons is not going to be considered a suspect class and could be rationally sustained. We looked at laws about voter IDs, and it seems like what the court has done is develop some kind of balance test about whether the voter ID requirement has some sort of reasonable purpose, and balancing that out against the burden it might apply to different groups of voters. We also talked about dilution and reapportionment, and this is kind of getting back to this question of how a state legislature sets up its legislative districts. And we said the basic principle there is one person, one vote. And this means that seats in the houses of a state legislature have to be apportioned generally on a population basis, so that each vote, each person's individual vote, sort of has the potential to have the same effect as any other individual person's vote. We then talked about political gerrymandering. And we said that generally, if it's found justiciable, and we talked about the fact that in many of these political gerrymander cases, there's a difficult threshold question of justiciability, and in particular whether it's really a political question and not something that's justiciable. But even when it's found justiciable, in general the courts uphold it and say that a political gerrymander, so long as it satisfies the one person, one vote principle, is okay. We've also seen cases that have said that the districts can be decided by a special commission rather than by a direct vote. We've also seen cases that have said that districts can be determined by total population rather than the total number of eligible voters. But as we talked about this, we talked a bit about the case that's currently before the Supreme Court and kind of the different twists and turns that can arise in this political gerrymandering context. We then talked about equal protection and access to courts. And here we have kind of a general principle that where it is access to the courts in a criminal context, the court is probably going to look at this a little bit more carefully, and where it's access to courts in a civil context, the court will look at it carefully if it relates to things that are kind of close to central fundamental interests like family. So if you kind of think of the background of fundamental interests, criminal, we have all these kind of due process protections and all these other privacy protections that we think are really important. On the civil side, what we are getting closer to the heart of those kind of interests is when we're dealing with family sort of issues. And really you have to just have a sense of the way the court has looked at specific circumstances and specific applications of this, and if you had a scenario kind of going forward, you'd have to kind of draw an inference or extrapolate from what the court has done. We then considered the question of equal protection relating to food, shelter, and education. And with all of these things, really, we're kind of talking about whether poverty or access to financial resources create suspect classes. And what we have seen is, so far, the court has said no. Well, there are no fundamental interests here in an equal protection sense. And as we talked about this, we said this is a difficult question that the court wrestles with, because to create a suspect class based on wealth would perhaps effectively be changing the notion of a sort of laissez-faire kind of capitalist system, and that's a difficult thing in a place where the court has been reluctant to get into. We then talked about Congress's civil rights enforcement power. We looked back to the civil rights cases in 1883, and those cases are looking at the 14th Amendment and are saying, and the civil rights cases say that the 14th Amendment does not give Congress the power to legislate, where the state generally has the power to legislate. General health and welfare legislation is still the domain of the state. But what the 14th Amendment does, and its enforcement powers does, is give Congress the ability to provide relief against state legislation or state action, and the courts the ability to provide relief as well. So there's this notion of what can Congress affirmatively do, and what can Congress do that is remedial. And from the civil rights cases, we kind of get the principle that it's really on the remedial side that the 14th Amendment is giving Congress some ability. We did look at also the public function doctrine, however, and we saw that there are circumstances under which an entity that is really a private entity is performing functions that sometimes the court will look at as effectively public functions, and therefore subject to direct regulation under equal protection. And so we saw that kind of early line of cases dealing with company towns, dealing with the white primaries, and in those cases the court saying, yeah, those are more like public functions and they're regulated directly by the 14th Amendment. But then we saw the court kind of back away from that. Things like just the provision of a liquor license, or things like a private utility that is regulated like a natural monopoly, the court kind of saying, well, that's not going to be a public function. And things like a private shopping center as well. So it seems like these public function cases are really generally limited to things like company towns and white primaries. We also saw, however, that there are cases in which access to the state courts to enforce certain kinds of private agreements, particularly racially restrictive covenants, can invoke the public function doctrine. We then saw how this concept developed in the court in looking at Bourne v. Flores. And Bourne v. Flores made particularly clear that what Congress can do in its enforcement power under the 14th Amendment in the civil rights context is only remedial, that Congress does not have the authority to interpret the Constitution and to enact legislation that says this is what the Constitution means, this is what the 14th Amendment means. Congress only has the power to enact legislation that enforces what the court has said the Constitution means. And we looked at the Violence Against Women Act case, and we looked at the question of congressional findings and how this relates to whether the statute is in fact remedial or interpretive. We then kind of briefly looked at First Amendment issues, and as I've mentioned, I don't expect you to have a kind of thorough grasp on this, just some general principles and maybe spot an issue. And when we looked at speech, we said content-based restrictions on speech require strict scrutiny. Time, place, and manner restrictions have to be content neutral, narrowly tailored. There has to be a significant government interest, so it's not a compelling interest, and other channels of communication have to be left open. And we've said there are some limited categories that the court has exempted from broad protection, which include things like fighting words and true threats. We then looked at the religion clauses, and under the Establishment Clause, we just sort of highlighted the most commonly applied test, which is the Lemon test, to determine whether something violates the Establishment Clause or not. And we said that the government action has to have a secular legislative purpose, a principle or primary effect that does not either advance or inhibit religion, and does not foster excessive government entanglement. And we just kind of gave, just as a brief example, speaking in class, the holiday display cases. And as I mentioned, there are lots of litigation on that, and go in various directions as you try to apply this. We then talked about free exercise. We noted that in Sherbert v. Werner, the court applied strict scrutiny to a employment benefits case, and that seemed to suggest that any kind of incidental burden on religion for an otherwise facially neutral statute would be subject to strict scrutiny. And of course, we did say that a statute that directly burdens and facially burdens religion is going to be subject to strict scrutiny. But this is a statute that is otherwise facially neutral that burdens religion. But then we saw that in Smith, in the peyote case, the court said, well, no, a law of general applicability that incidentally burdens religion is not subject to strict scrutiny. We saw then that Congress responded to this by enacting the RFRA statute. We saw that the RFRA statute in City of Bourne is not applied to the states. We saw that the RFRA statute still applied to the federal government, and we saw how all that worked out in the Hobby Lobby case, and the court deciding that at least closely held corporations have religious liberty rights that they can assert under RFRA. So with all of that catches us up on our review. I hope this is helpful to you. I want to give you all best wishes for the exam. I know this is a lot of material. I'm sure you'll all put in a lot of effort, and also happy holidays. And I will see you around the law school.